Initiative.
It's a wonderful initiative.
The GlobalSouth network opened new horizons for judicial cooperations.
GlobalSouth network provide a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN. The GlobalSouth Network is a much admired initiative.
كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Quiero expresar mi sincero agradecimiento al Dr. Nauman Riad.
Dr. Nauman Riad, the founder and convener of the GlobalSouth Network. His visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas. Initiatives like today's dialogue allow us to compare jurisprudence, share best practices, and develop common principles. This has the potential to contribute to transnational standards in procedure and enhance administrative law globally.
I would like to point out that Dr. Riad's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism.
We can rule when we want in the cases which are brought to us by citizens and residents. In the EU, this openness of mind is increased by the fact we apply, in some cases, same norms from the EU treaties or the EU directives or regulations.
After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings?
Good afternoon, everyone. It's my great pleasure to welcome you all to the 43rd seminar in Phase 4 of the International Interdisciplinary PhD in Progress weekly seminar series organized by the GlobalSouth Network. Now, before we begin, I would like to extend my sincere thanks to Dr. Umana-Dajud, lecturer in law at Leicester Law School and founder and chief convener of the GlobalSouth Network, for his tireless effort in organizing and leading this inspiring weekly series that continues to bring together scholars and practitioners from across disciplines and regions. So to introduce myself, I am Dr. Eric Leflad. I'm a lecturer in law at the University of Kent Law School. My primary research focuses on the multifaceted coevolution of international law and modern political consciousness. And towards that end, I'm especially interested in the historically rooted material aspects that shape the international legal order's simultaneous enabling and constraint of radical political transformation. And it's a real pleasure to chair today's Global South Network PhD in Progress session, and I'm very, very much looking forward to hearing about the presenters' research, their ideas, and the rich discussion that will inevitably follow. And I'm joined by today, in addition to our speaker, by two discussants and two peer commentators. So Dr. Goran Basic is our first discussant, who is an associate professor of sociology and senior lecturer in education at the Department of Education, Linnaeus University. His research concerns social and pedagogical processes and collaborations among different actors in school, university, youth center, youth care, social care, police, and Coast Guard. He has also written articles on post-war society and carried out an evaluation of several projects in juvenile care, analyzing policing practices in the Baltic Sea area and the experiences of young people who have lived through war and have been placed in Swedish residential care homes for children and young people, as well as the experiences of the institutional staff who work with these young people on a daily basis. Dr. Dimitrios Kourtis is the second discussion for today's session. Dr. Kourtis holds a PhD on genocide and the right to exist in international law from the Aristotle University of Thessaloniki. He is currently a postdoctoral researcher and teaching fellow at the School of Law of the Aristotle University of Thessaloniki and an adjunct lecturer at the Supreme Joint War College of the Hellenic Armed Forces. He is an accredited public policy disputes mediator and a national expert on international criminal law and reparative justice, providing specialist services to the Inter-Party Parliamentary Committee on World War II reparations of the Greek Parliament. Catalina Hernandez Mora is the first peer commentator for today's session. Catalina is a PhD student at the Faculty of Law, University of Cambridge. Through her PhD research, she aims to enhance state compliance with the duty to prevent genocide by developing a set of criteria for allocating individual state obligations under this collective duty. She seeks to critically assess the Genocide Convention and the role of the UN Security Council with the goal of helping realize their unfulfilled potential as instruments of genocide prevention and as a pillar of the international rule of law. Eva Rasmus Setkovic is the second peer commentator for today's session. Eva is an assistant at the Institute of Criminology at the Faculty of Law, Ljubljana, and a doctoral student at the Faculty of Law, Ljubljana. In her doctoral thesis, she examines the social harm caused by space technology and possible ways to respond to it. In her broader research, she deals with the criminological and legal study of the development of new technologies and their impact on society, the perception of evil and violence, human rights, and the environment. Finally, it's my great pleasure to introduce our guest speaker for today's seminar, Ayesha Umana-Dajud, who is a doctoral candidate in the Science of Law, J.S.D, at Cornell University. Ayesha's professional experience spans roles at the Office of Public Counsel for the Victims of the International Criminal Court in the Netherlands, at the Special Jurisdiction of Peace created by the 2016 peace agreement with the FARC-EP guerrilla in Colombia, and legal research positions for the Women and Justice collection of the Legal Information Institute and the Death Penalty Center in the U.S. Recently, she argued at the Inter-American Court of Human Rights on the advisory opinions on climate change emergencies and human rights 2023. Today, Ayesha will present part of her PhD project entitled A Geography of the Global Governance and Legal Local Culture of the Crime of Genocide. She will speak for about 30 to 35 minutes, got my sign here, followed by 5 to 10 minutes from the comments from our discussants. And if time permits, we will open the floor for a 15-minute Q&A session with the audience. Ayesha, we're delighted to have you with us today. The screen is yours.
Thank you so much, Professor Lovelock. I am very happy to be here. Last time I had to explain my dissertation to somebody was to the customs officer at the airport in the US, finding out if I could enter the US or not. I could. Probably the explanation was different, but I'm very happy to be here to talk on a dissertation that comes from a long time of human rights advocacy, initially in my country, Colombia, and then expanded to the rest of the world. When I was working in the Peace Tribunal in Colombia, I was hearing to the request of the victims of the genocide against the political party Unión Patriótica, which was exterminated in the 80s. In 3 years, more than 3,000 members were killed by policies of the government. And I was asking myself, do the victims know that internationally political groups are not protected? Is it ignorance, or they do know that and they still request it, and they have reasons for that? And when we check the Colombian Criminal Code, well, the Colombian Criminal Code protects political groups in the crime of genocide. So I came outside, I said we need to learn from others, also frustrated by a lot of questions in transitional justice and international law. And I began to present this topic to peers, to colleagues. And when I was introducing the topic that other countries protect different groups than the 4 protected in the international definition in the Genocide Convention and the Rome Statute, most of the people were interested, but asked me, okay, which countries? Coming from Latin America, I began to tell, well, Colombia and Costa Rica and Panama, Nicaragua. They were like, oh, okay. They were not very interested. Then I said, oh, but European countries too. And I was regaining the attention. They were like, which ones? And then I was saying France, Lithuania, etc. All the list of countries. And this was very frustrating for me, because it was like if the Latin American countries were less in this change than others experience. From there, I told myself, well, we actually need to understand what's going on in the world in terms of protection of groups in the crime of genocide. And I sat down, tried to find legal databases with all the criminal codes of the world, which, to my knowledge, there isn't any that's completely updated. And databases of the crime of genocide everywhere, which are not updated. Some of them are very useful, but there wasn't. So I had to sit down and look for the definitions of the crime of genocide everywhere in the world. And from my research, I found some very interesting results, where 67% of the UN member states, of the 193 UN member states, protect the same 4 groups in the international definition. 27% have added or deleted protected groups in the definition when implementing the Genocide Convention in their national laws. This is 52 states. It's not just a bunch of states, Latin American or European states. It is a worldwide modification, and 6%, which is just 11 states, do not recognize at all in any national law the crime of genocide. So to understand it very quickly as an historical context is that when negotiating the Genocide Convention between 1946 and 1948, after the World War II, the countries were discussing what should be the definition of genocide. And this is interesting because this is one of the crimes that was first created normatively internationally and then was introduced to national laws, which is not something very common for most of the crimes in the criminal codes. And I went to the negotiations, to the 2,000 pages of negotiations, which thanks to Professor Saptahi and Webb, who did an amazing compilation of the UN documents, I began to read this discussion about particularly political groups, which was my main interest in the beginning of this research. And political groups were protected in the definition of the Genocide Convention until almost the very end, just at the very end of the negotiations when they were deciding the most important points. they decided to delete it. Maybe because of Lemkin's argument that they were not stable and identifiable, or probably because of other reasons. Here you have a graph I created from the voting at the UN discussions. These are the most important, more critical points that were discussed at the very end, where you can trace back the call by roll votes of the countries. And here we have an interesting situation. I'm not going to explain everything. Yeah, you can read it when the chapter will be published. But number one is a discussion where the countries decided to maintain the protection of political groups in the Genocide Convention. Number 8 is when the countries decided to delete any mention of an international tribunal. So we maintain political groups, we delete international tribunal to prosecute the crime of genocide. Number 14, they get into this crisis, the countries, because there is no international jurisdiction at that point. It is this crisis here. And in number 14, the countries decide to delete the political group protection. And in number 16, they decide to include an international penal tribunal. So it was sort of a trade-off, more than an explanation of permanency and stability. If we think about that argument today, there is some political groups that have been more stable than some countries of the world that have, from 48 to today, changed quite a lot. But let's dip. This is the first chapter of my dissertation. I'm not going to dip in this one. Let's dip in the second one. That has been pretty interesting for me. And the question is, how have the national legal systems around the world redefined the category of protected groups in the definition of the crime of genocide? And what does this reveal about the diversification of international criminal law? Here, when said I'm taking the lenses of diversification, there is also fragmentation and harmonization. I take the lenses of positive diversification because, since I mentioned that this was a crime created internationally in 48, where only a quarter of the countries of the world existed, and most of the Global South didn't exist in the UN General Assembly, so they didn't take part of the discussion of the creation of the crime. I say there's a good evolution trying to address the needs of local justices of the countries and their instances of very high violence. So from what I was saying, my results found that 67% do agree with the four groups: national, ethnical, racial, and religious, but 27% change the protected groups. And added among the different categories will be a tendency of adding a group determined based on any arbitrary criteria, which is more or less any group, depending on the condition of the state. Then we have countries that decided to add the political group, countries that decided to add the social group. And then we have other groups such as color, cultural groups, tribal groups, disability groups, sexual and gender identity, origin or descent, some other definitions of what will be a national group or a religious group. And I also found that a group of countries, I am missing the number right now, but like 15 member states deleted groups. So they deleted either racial, ethnic, or national groups, and 2 countries, Bolivia and Vietnam, created completely different definitions of the crime of genocide. And this was very interesting to my eyes, because I was asking myself, what's going on here? The international discourse that created this definition was pretty strong in the implementation. Article 5 of the Genocide Convention created the obligation for countries to implement it in the national codes. Some countries didn't, arguing that the tendency where they applied directly international law, but this is not enough, since the Genocide Convention purposely didn't determine a penalty for the crime of genocide. Additionally, the Rome Statute copied exactly the definition of the crime of genocide without any discussion, and the Rome Statute, as we know, has a general penalty for all the crimes, but nothing specific for the crime of genocide, which is a problem when judging the crime of genocide national. But let's go into these countries into the groups, and I'm gonna probably focus on three main big groups that were the most adopted, and then a little bit on the deleted groups. I'm not gonna go through all of them because it will be way too much, but let's see some tendencies. So one of the tendencies is a group determined on the basis of any other arbitrary criteria. This was a formulation that was mentioned in the negotiation genocide convention, but was not really taken care of. And maybe the most important country here created this definition was France. And then, as we can see, from these 14 countries, that added this definition, 13 or 12 were former French colonies. So we can see that clearly this was a colonial influence, and these French-speaking countries that were colonized at some point by France decided to copy the definition introduced by France. It is an interesting definition because it allows countries to protect any group that is subject to extermination, any identity group that's subject to extermination. There is not much jurisprudential development on the topic, which causes a problem. They haven't really applied it, partly probably because some international courts, and in specific the European Court of Human Rights, has said that it is not possible to expand the list of protected groups because it's part of the international definition and use coherence. Yet countries have done differently, and other international courts have decided to take it differently, such as the Inter-American Court of Human Rights, in the case of the political party Unión Patriótica in Colombia. Then we have a couple of other countries that were more minoritarian, and we have Finland and Georgia. These trace back, and I'm going to dip in political groups more in this, trace back to histories of resistance of occupation from the USSR. And all these groups that were resisting this occupation, either ethnic groups, either political groups, either social groups, there were different developments, but it is this big group of the countries that were resisting this occupation. And then the other one, Georgia, not exactly like Finland and the Baltics, but it had a big influence from France because France gave exile to most of the political leadership of Georgia when they were occupied at the time. And we can begin to trace back those relationships. Now, the political groups. In the political groups, I found two big tendencies. So first is that some describe it as political group, some describe it as ideological group, and some describe it as group resisting an occupation. Two big tendencies, Latin America and the former occupied country by the USSR. Go back to Colombia and Latin America. In half of Latin America that decided to modify the protected groups, and the main tendency is political groups, among them Colombia, Costa Rica, Ecuador, Panama, Honduras, Nicaragua, and Haiti. And this is probably because of the very high events of political violence in Latin America. So two tendencies here, Colombia and Nicaragua and Honduras. Colombia, long armed conflict, mainly because of political reasons. We have in Colombia, the Supreme Court, Constitutional Court, peace jurisdiction recognized the genocide against the political party Unión Patriótica, and probably extending it to other left movements in the recent decisions of the peace jurisdiction. Ecuador and Panama, well, just neighborhood countries that probably feared same situations. Right now, Ecuador is going to very high levels of political violence, which will be very interesting to develop more on it, but they have not decided any political genocide in Ecuador. Honduras and Nicaragua, they have this shared history where when the Sandinista government was in power, they decided to force deport the Miskito indigenous people to Honduras. Why? The Miskito indigenous people had relationship with the extreme right-wing movement of Contras. that was supported by the US and that there is an ICJ decision on that. 6 months later, the Nicaragua government decided to ask for pardon and brought back the indigenous to their territory. So these two countries share this very strong history of political violence. And I'm just going to say about these countries that I'm right now doing my field work on these countries, trying to find out what was the victims' advocacy to manage to change the international definition, both in Nicaragua, Honduras, and Colombia. Colombia went very well. I have all the information. Interviews. Nicaragua and Honduras have been almost impossible to access the information. Nicaragua, I got the information from the Legislative Archive in 2023 before the government deleted all the archives from the website. And when I tried to have help of research assistants to go to the Library of the Congress, they were too afraid to go. And I decided to stop my trips because it was too dangerous. Honduras, I haven't been able to access the archives at all. They don't answer. I know where they are. 3rd floor of the Secretary of the Congress. Nobody can enter that place. They're not in the library, even if this is from 2017. And then we have the other groups that are the ex-former USSR, Lithuania, Poland, Slovenia, I know which others are here, which together with any other arbitrary criteria and social groups are this reaction to the Soviet occupation, where there is a lot of discourses of an extermination against different groups. It can be Rom people, it can be Jewish of those places, or it can be the partisans that were resisting the occupation. And that's the specific case of Lithuania, which is fascinating because there was a whole discussion between the Lithuanian Supreme Court and the European Court of Human Rights, trying to convict high officers that worked together with the USSR for the genocide against the Forest Brothers and other partisan groups that were resisting the USSR occupation. First instance, they were convicted, then goes to the European Court. The court says they cannot protect political groups in the crime of genocide. The Supreme Court of Lithuania changed its interpretation to say that the partisans not only were a political group, but also are a substantial part of the national population of the country. And that's how they end up to protect part of the national population, goes to the European Court again, and then the European Court says, yeah, this is okay. And then we have Switzerland, later Liechtenstein, and other countries that joined the UN General Assembly very late on, 2000s almost, try to keep this independency from the geopolitics, didn't participate in the Genocide Convention, and added other groups such as this case. The other group I'm going to very quickly touch is, well, we have already been talking about the groups that resisted occupancy. And then, of course, maybe some classifications are not the best. It's more for the analysis. I don't know if case groups can be put in social group, religious group. This is very difficult in the case of Nepal. But the point is to say that because of other social organizations, some countries added groups as social, other formulations of class and caste. The case of Peru and Paraguay, honestly, there is not much information why this happened. There is a guess that it was because there was violence, particularly by the two military dictatorships in these countries against indigenous people, which were also related to a very low income class. And that's why probably it was not stipulated as an indigenous group or enough with the racial or ethnic group, but they really wanted to protect this idea of a lower class. And then we have, not going to dip in, maybe I'll just say that color skin is particularly interesting because most of them are countries with colonized traditions where most of them deleted either racial group, either national group, and they were saying, well, we were exterminated because of our color skin. Whatever race or ethnicity means, those are European concepts we don't really adapt in our countries. And then we have all these others, Probably one of the most expensive protection is Canada, that adds sexual and gender identity, disability, and others. Because of time, and for me, it will be very interesting to receive feedback from everybody. I'll touch a little bit on the deletion of groups. So some groups decided to delete racial groups, ethnic groups, and national groups. It's hard to track back about what has been deleted and not what has been added, because sometimes in the legislative debate it was directly presented like this and it stayed like this. It depends on the cases. But here we have some explanations of critical race theories, decolonizing thought that we can see. And maybe I'll just explain the case of Oman. Oman is an interesting case because it only adds three groups: national, religious, and a third one that can be racial or ethnic, or none of them. In Arabic, the concept of race or ethnicity doesn't really exist as such. So some countries like Arab Emirates or Sudan added a fourth category that's called ethnia and kept the Arabic word that's arkia. And pardon me for the Arab speakers for my pronunciation. I'm keep trying to learn. My grandfather was from Syria, actually, a bit like Shakira, that you have Colombians and Syro Lebanese, but I'm still learning. But the concept of arkia does not necessarily mean racial or ethnic. And ethnia, it's a word that was taken from English. It didn't really exist in Arabic before. And when we think about the fact that they just kept three groups, so you think, what's this ethnic, what's this racial, or none of them? When we go to, because Arabic is a Semitic language, we go to the root of the word to understand what was the concept in the language. And archaea comes from the idea of the root of a plant. The descent, like when you put it in a human group, it means the descent of the persons, whatever that means, the origin of the person. And when you talk with our people, for them it's very interesting it's very important to understand where your parents were from, where you came from, not necessarily your race or ethnicity, but where were you from? Whatever that means, of a group, a country, a region, and it's a different concept. And Oman purposely kept just this concept. Finally, Bolivia and Vietnam have completely new definitions of the crime of genocide. Bolivia has had, in the last century, a very strong reestablishment of indigenous people rights, has changed the concepts of the law there, and it's clearly a decolonization of their criminal law, and they very directly protect groups of peasants that are also indigenous people and other groups. But this was very important. And also the ecocide is in these definitions where they really protect the environment together with that. A different concept from what was created in the Genocide Convention. And Vietnam too. They try to talk about the people in a territory, very territorial, not much of an identity group, and they also related to the environment of those people. So from this review, some scholars did the review before, but not a systematic review like this. We can see that first, the modifications of the protected groups in the crime of genocide that were triggered from the implementation of international law are a lot broader than we could think. A third of the world is not few countries. It is a tendency, and it is a very interesting tendency. And here I am only focusing on the protected groups. But if we go look about the acts, the list of acts, there is other diversifications. And probably further research will be interesting to do about all the crimes that are described in the Rome Statute, because it means there is an evolution of what was created in international criminal law, and it is adapting to the country's needs. Sometimes maybe, authoritarian way. Ethiopia received a lot of critiques. They have these two transitional tribunals that have been judging political genocides. Ethiopia has had very strong problems of political violence. And there is denouncers from Human Rights Watch that the procedures are not do not have high standards, which is probably true, and they're changing the charts for that. Then we have other countries like Equatorial Guinea that had also a decision on the crime of political genocide. I have not been able to act on a report from an NGO that were at the trials and could do a report of them. And there is some decisions to try to find. I haven't been able. If somebody has access to them, I would love to be able to read them. But there is a lot more judicial decisions on the crime of genocide in national tribunals than we can think. And if we think internationally, the decisions that have convicted for the crime of genocide are not many. We have Srebrenica, we have Rwanda, we have ongoing Myanmar, we have the ICJ with the jurisdictions, ICC not really. There is not many convictions that really decide that this person was tried for the crime of genocide. In terms of the Nazi officers, almost none of them except for Eichmann, because the crime of genocide definition didn't exist at the time of trying the Nazi officers. It was embedded somehow in crimes against peace, but the concept was not developed. And from these tendencies and see how these countries are trying to address their needs of justice and trying to prevent or punish the people that are trying to exterminate another group because of their identity or any other arbitrary criteria, as we had in the first definition, we can see this evolution trying to adapt it to their histories and their needs. There is this decision on the Argentina case that was done by the Spain US Supreme Court that had an interesting concept that was not normatively applied later, but it's the idea that the perpetrator will define the identity of the victim. Not like the victim had its own identity, but they created an identity that can be an enemy, in which they put a lot of people, such in Argentina, all the persons that were against the moral expected by the government, including political left wing or LGBTIQ or others, and that the concept of identity actually was created by the perpetrator. I don't want to take any position on which should be the group protected. It's really depends on every single country and their histories. There is this studies about how international law has become hegemonic and impede other narratives to develop. So I don't want to reproduce that. In my research, I just want to say, actually, we need to listen more directly to the Global South. A lot of these countries are from the Global South. A lot of the countries that live genocides today are from the Global South, and we need to listen to the victims because they maybe have something to tell to us, and this is exactly the case. Thank you so much for listening to me, and I'm looking forward to hear your comments.
So thank you very, very much, Ayesha. That was a fascinating presentation. I mean, so much to really be thinking about in terms of what does it mean to have this universal definition of genocide in a world where identity is constructed in so many different ways. And I hope presenting that to us was a much more pleasant experience than discussing this to the U.S. Border Guard. So,
for sure.
Well, we are all honored. Well, I'm sure our commentators and our peer discussants have a lot to offer in response. So, who'd like to get started? Oh, Catalina.
Hi. Thank you so much for the invitation. Gracias, Ayesha, for such a fascinating presentation. Congratulations. So I have one comment, and please feel free to answer to whatever you want, because I don't want to take more time than strictly allocated. But I have one comment and a couple of questions. So the comment is firstly methodological. I was going to ask you about any difficulties you faced, any methodological challenges you faced during conducting your research. I feel that, and I wanted to comment this and congratulate you, that the example you provided on how the Arabic word archaea, and also sorry for my pronunciation, I too am learning Arabic, very hard, really reflects how not all languages have the same concept. So I was very grateful for that for that example. And then I have two questions, which are more a matter of substance. You said that 15 UN member states deleted protected groups from their definition in their respective domestic legislations. And my question is whether any of these are signatories of the UN Genocide Convention, and if so, if their protection in that case is limited to regional courts and dependent on the approach that regional courts have to the matter, because I understand that recourse to the ICJ is obviously out of the question by individuals. That's my first question. And then I'm really curious if you can provide a bit more insight, if you do have it, on why Austria, because I find it a very stark example, eliminated from its definition ethnic and national protected groups, considering the history of that country. Because I understand, as you mentioned, that the history of a country, like with the example you gave of Unión Patriótica in Colombia, plays a very, very relevant role in the definition that countries choose to give to the crime of genocide. Yeah, and again, congratulations again. Thank you.
Okay, thank you, Catalina. Dimitrios seems to have one, so Dimitrios.
Thank you. First and foremost, allow me to congratulate you, Ayesha. It seems that this is a really fascinating project. And as a person who has also researched the various aspects of the Genocide Convention in my own PhD, I'm really excited that we see fellow scholars really amplifying the research and basically focusing on very, very important yet understudied and overlooked aspects of the Genocide Convention, including domestic criminalization and basically what we call in international law and comparative law normative mimicry. That is taking a snapshot from the Genocide Convention and introducing it into a penal statute, a criminal statute, or some kind of ratification or sanctioning law. I have two questions and one observation. The first question is out of confusion, to be honest. I've taught international law in Cyprus, and I see you mentioned Cyprus many times in your table and in your slides as a member state that expands the definition of genocide. To my own understanding and to my own knowledge, both the sanctioning law of 1980, but also the modification law of 2011 do not do so. They just reproduce the text of the Genocide Convention. So if there is something new, or you are meaning something else, or you have in mind something else, please do elaborate. I'm very interested in that. This is my first question. My second question has to do with how you understand the well-known interpretive battle between scholars, but also between courts, from the between subjectivism and especially pure subjectivism, what you brilliantly described as imagining the group as such in the mind of the perpetrators, either the physical perpetrators, the foot soldiers, or the criminal masterminds, most of the time. This is pure subjectivism, which, according to my own understanding, I have published this, so I can say that, it's basically taking away agency from the victims, because it accepts that ascriptive identities, they do not exist. They are only imagined. But pure subjectivism is very, very popular among both European and, generally speaking, global North-based scholars on the one hand, and also international criminal tribunals on the other hand. So we have pure subjectivism, we have also objectivism. Both are kind of, superimposing their own understanding on the understanding of the victims. So how are you dealing, and do you plan to deal with this interpretive battle? I have also, let's say, devoted many chapters in my own dissertation and my published research about this legal battle, so I would love to hear any fresh new thoughts or your own approach. Second question. One observation which kind of has to do with dealing with the travaux préparatoires of the Genocide Convention. I know they are very interesting, I know they have a lot to offer, but sometimes they do not tell the whole story. My own research, for example, showed me that to understand a lot of interesting questions or points, especially regarding the protected tetrad, the four groups protected by the basic sanctioning norm, Article 2 of the Genocide Convention, or Article 6 of the Rome Statute, or any other normative mimicry of this provision, you'd have to dig deep into diplomatic correspondence, into the various allegations that state raised. For example, you mentioned Nicaragua. Nicaragua, immediately after the fall of the Somoza dictatorship, Nicaragua brought a claim of auto-genocide against both the Somoza regime, but also the United States of America. This happened within a political forum, the United Nations General Assembly. This is also interesting, for example, to understand a part of the Nicaraguan struggle regarding the Genocide Convention. During the Cold War, we have 0 courts, but we have the General Assembly of the United Nations being the primary forum for bringing genocide claims. I have a lot of unpublished research on that, so if you want to, yes, I can actually help. This was something that could not be included in my PhD because it was already huge. So take this into account. Another example, the so-called, genocide by mental harm. Also, to understand that, you have to see what China was saying at the Narcotic Committee of the United Nations, not the ad hoc committee or the 6th committee mandated to deal with the Genocide Convention and the drafting and so on and so forth. The idea about national and ethnic also. For example, you don't know, but in Greece, we, through interpretation, conflate the two terms because in our own words, in our own legal language, but also vernacular, they are not different. National and ethnic kind of mean the same thing, and we have a neologism to describe ethnic. So if you read, the big textbooks of the initial period of adapting the Genocide Convention into our own domestic legal order, they would say this is something that Westerners, that Europeans, or that, the English-speaking world does. For us, for Greeks, and for the Greek legal science, national and ethnic are the same. And the problem is that Greece actually used that to depoliticize and also de-racialize and excise from the corpus of the national community communist partisans during the first confrontation of the Cold War, which was the Greek Civil War. Also important because it affected the Genocide Convention more than any other event during the Cold War and the drafting of the convention. The forcible transfer of children is because Greece actually alleged that the communist partisans were committing auto-genocide with the complicity or with the support and assistance of the communist northern countries, neighboring northern neighbors of Greece. So this is also an observation. Thank you again for this wonderful presentation. I'm really looking forward to reading more of your research.
Thank you so much for invitation, and thank you so much, Ayesha, for interesting presentation. I'm going to try to continue in the line with the previous comments from my colleagues Kalina and Dimitrios. And I think that is an important point that Ayesha dramatizes in her presentation is just problems with the definition of term genocide or crime of genocide, in meaning that is a different country which doing definition in a different way and so on. I think, Ayesha, for continue of your research, that is important that you're thinking in the terms of what is my own definition of this phenomenon that I want to investigate. Because, of course, between different countries, this is different starting point related to the ideological aspect and phenomenon that Ayesha presented today, but in the meaning of the research subject, that is different definitions. For example, jurisdictional, legally definition of the crime of genocide is very interesting in meaning of these different countries and the different conflicts that we have in the world. In my own research, I was using a sociological definition of genocide in the meaning genocide as process. And I think this starting point is important for your continuing study, in meaning to doing easier for you and doing easier for people who following your work to have one, we can say, partly definition of term crimes of genocide which you use in your study. That is one comment or recommendation. One another thing what I want to ask you about related to the Catalina's comments about your methodological starting point, in meaning in which way methodologically you work with your research. I think that your result you presented today is very interesting, but that is the important to think in methodological meaning, okay, what I do, how I do, and with help of which methodological research would I do that? Because in this meaning, research is different from another kinds of activity. And last, if you have time for that, I just get abstract about your dissertation. So I'm really interested about if you can tell us a little bit about your planned fieldwork with semi-structural interviews and next step in this work you're going to do. How, even in that case, with which methodological starting point. I think that is important research that you do, and I wish you all good luck in the future.
Hello also from my side. Thank you for the invitation, for the opportunity to listen to Ayesha's very interesting work. And also I would like to join everyone else's acknowledgement of the importance of this research. My questions mostly relate to the consequences of your preliminary or also in your final conclusions. Since you pointed out that there are patterns of decisions of states to include or to include more groups or eliminate some groups, that mostly to include them in the definition. And I'm really curious if you see here any potential for this crystallizing into customary international law, since you're identifying some early trends, and what does that mean in broader picture for general phenomena of fragmentation of international law that international law is being very often accused of. And in one way, your conclusion deemed this as something more positive, so adapting to different states' contexts and relying on historical experiences and more thoroughly acknowledging those historical experiences. But on the other hand, I'm interested if you also looked into certain negative implications, so with regard to perhaps fragmentation, or also perhaps a different perception of what genocide actually is. So whether this is something that is focused on exterminating the group based on a criteria they have no conscious or they have no agency in, so something that they cannot choose, or something where there is a clear agency of the victims in choosing to be part of that group. Also, I'm very curious whether you had a chance, or whether there actually exists a chance to look into the question if those of the perceptions of states that differentiate from the Genocide Convention actually play a role on international level, perhaps within the proceedings before International Court of Justice or International Criminal Court. Now we're seeing a lot of interventions in the open cases before ICJ, so it will be really interesting to see whether those different perceptions come into the argumentation, or can be at least seen as influential to the argumentation that the states are presenting, or this is something that states clearly distinct, so their own perception in the domestic level and their understanding of international obligations. I'm also aware that this is perhaps not essential to your research, but these are the questions that I think your research will open up. And I'm just curious whether you thought of that in advance, or this is something that you will perhaps address in the future. I think that would be all from my side. Thank you again.
So thank you very much to our discussants and pure commentators. So that's a lot of questions, a lot of different angles of your research. So now, how much can you address in 5 minutes that we have left? So Ayesha?
Well, thank you so much, Catalina, Dimitrios, Goran, and Eva, for your comments. They're extremely generous. All of them make a lot of sense. Obviously, I won't be able to answer, and I wish I could take more time with you just to discuss the topic. Catalina, in terms of the deletion of the countries of groups, yes, countries. There is a whole part where it tries to study the relationship with the Genocide Convention and the Rome Statute of the countries that deleted the groups. I'm not going to make the list here right now because of time, but I would just say that there is a question that I don't want to answer, honestly, and it is because of use coherence, is this against international law? Because we have the Vienna Convention, use coherent norm that makes void any international treaty that goes against international law. And then we have some courts that have say, well, actually expanding the protection is not against international law. It just have a national protection, but it doesn't go against. Does the deletion go against international law? Probably yes. Does it make void the norm? Probably not. It's just that the national protection should also add that group. But I don't want to give that answer because I don't want to reproduce this hegemony and this maybe probably colonial thought into the national systems. And it is an open question. It is open in my dissertation. I don't want to take a position there. I am very scared of reproducing narratives I don't want to reproduce. But that would be a bit the legal argument. In terms of methodology, yes, a lot of obstacles. I would just say databases. For me, it's outraging that we don't have a updated criminal codes database in the world, something as simple as that. And it took me a lot of time of rebuild it. Also, it is a problem, the language. I am grateful because of my history. I speak 5 languages, and that helped me a lot in doing the research. Others I don't speak. AI has been the most amazing tool to try to understand all the codes. As the crime of genocide has more or less been harmonized, it is possible to do this. But of course, there's going to be issues in doing this. Then legislative debates are not always. I was saying the story of Nicaragua, it's been impossible. Honduras, it's been impossible. And it's just one of the cases I took because of my personal relation to the territory, not other reasons, but of course, I'm pretty sure this happened with others, or access to decisions, court decisions that are not available and should be available. And in terms of Austria, I'm not going to dip in, but I'll just say that they replace it by tribal group. Why? I'm not very sure. I still need to go to the legislative archives to see if I find something, but they did replace it for tribal group. Dimitrios, I have 1 minute. Okay. Cyprus and Greece, it's in terms of advocating for the crime of genocide that changed the protected groups. I'm sorry if I put it, maybe I shouldn't put it like that in the table. I was just trying to show the bigger picture. They keep the definition of the crime of genocide, but when they introduced through the European public policy of going against hate crimes, they did a very strange formulation that if a Congress or an international court's decision in the case of Greece, or just an international court decision in the case of Cyprus, recognize a group different than the one in the definition of the crime of genocide, then we have the crime of advocating for genocide for other groups. And I would love to keep in these discussions. I did see all these things around China and Nicaragua in the Genocide Convention negotiations. Of course, I don't have all these other ICAs you have that will be more than interesting for my research. Goran, you're right. I took my time to go to other social sciences because Latin American tendency, I consider law a social science from my point of view. But to other social sciences, sociology, anthropology, political science, definitions probably involve a lot more complex and understanding the phenomenon. That's very true. There is always this complication between language of the fields. And I still needed to say somehow in the legal framework as I'm a legal scholar, even if I don't completely agree. And the social science have been extremely useful to try to explain phenomena that I cannot explain legally, because there is no legal information about that. I don't want to do my own definition because I remember the name, it's Benjamin Mises. I don't want to impose a definition. I want to show something that's going on in the world that has reasons and open this discussion to the scholars, because it has a lot of value. Eva, just to conclude, the use Cohen question is very important. My chair cannot stop telling me about this question. I don't know if this is going to crystallize into new discussions. We will need a treaty ratified by the whole community according to the Vienna Conventions to make it use Cohens. To be honest, I don't even know if use Cohens even exist as a concept, because I wonder if it is possible today that 193 states agree on something completely. Looking at today's world, it seems very hard. And looking at when they decided what's use Cohens, it's been a while ago where the country were just 60 states or something like that. So it is complicated. It is a complicated concept. I don't want to destroy it neither, because it helps human rights advocacy to try to go to other instances. It is such an important tool, but it is very complicated concept. I don't know if we need to crystallize it even in a use Cohens norm, if that's necessary for the victim's right. Negative implications of my research of these results? Well, yeah, probably use Cohens wise too. That it is unclear what the whole community is agreeing on. We can be afraid of diversity or we can embrace it. We have both ways. There is pros and cons in every situation. And the perception of states play a role in international law, yes, we can see it in the negotiation of the Genocide Convention. It's probably further research. I don't know. I don't think I'm going to delve into that, but thank you for the question. I haven't said to think about that one, but a lot of ideas can come to my mind already from what I've read. I hope I managed to answer some questions very quickly. I'm sorry if I took too long in Catalina because you were the first, but all of them were extremely generous, and thank you so much.
Oh, thank you, Ayesha, and thanks to all of you. That was quite the stimulating discussion. I mean, could really go on. I mean, I've got plenty of questions of my own. I'm sure the greater audience does. But guess we'll have to wrap it up now. So many thanks, well, to our presenter and to our discussants and commentators, and also many thanks to Numan Rayat, who set up this GlobalSouth network, and yeah, brings in PhD students from all different disciplines to present. And if any of you in the audience are interested in presenting, here's his email right there in the chat. So get in touch with him. Take care. Look after yourselves. Have a wonderful day. So goodbye, everyone. And thanks again so much for being with us. Hi. Take care.
Thank you so much.
Bye.
Thanks, Eric, for excellently chairing the session. Thank you.
Oh.
Thank you.
Thank
Thank you,
you.
everybody. Thank you.
Thank you so much. Bye-bye.
Hi.